Bob and I had a spirited disagreement over settlements of civil cases. It was Bob's position that in settling a civil action, asking for anything more than actual costs constitute fraud. I think that is a preposterous position to take. It's not consistent with the position of the Florida Supreme Court. It's not consistent with the Florida bar rules. It's not consistent with the Florida rules of civil procedure. If you and I are engaged, as we are, you and I are engaged right now in an ongoing civil matter. If you propose to me or I propose to you settlement of that matter, which for the record is a nonsensical, frivolous lawsuit, but be that as it may, if I say, Marty, I'll settle the case, but I want you to stand in the corner on your head and gargle peanut butter, I have every right to do that. There's nothing unethical about me asking you to do that. It's not going to happen probably, but I can certainly do that. I could say to you, Marty, I want you to give me $10 million to settle the case. There's nothing unethical about me doing that. It's probably not going to happen. Is it?
You say it?
yeah, probably not. There's nothing unethical about that. I mean, in civil litigation, when we get to the whole point of settlement is that during civil litigation, the only entitlement that anybody has is due process. So when you get to settlements, the whole point of it is to ask for things that you're not entitled to. That's the whole point. And so Bob and I had a very spirited, it was friendly, but very spirited disagreement about that. He thinks, I'm sure he would, based on what he's describing, what I do in civil litigation is fraud. That's utter nonsense. It's not fraud. Sometimes it's referred to as buying your peace or whatever. People decide that they don't want to go to court because they are afraid of what the outcome is going to be, or they decide that they're just tired of it, or they decide that they don't want the bad PR, or they decide that, whatever. People can engage in civil and settlement negotiations and civil matters all they want, and as long as they're not asking somebody to perpetrate a crime, I think that it's fair game. And so Bob was very adamant that asking for anything more than your entitlement is fraud, and that's silly. I saw the statistics not long ago. I think it's 96 or 97% of all civil matters in the state of Florida are settled without, going all the way through the process. The courts would collapse if everybody decided we're not going to settle anymore. And settlements, by their very nature, are a series of discussions that involve people asking for things they're not entitled to. They do it all the time. Judges sign off on them all the time. So I think Bob and I have a very different view of fraud. I would say that a company who contracts with the state of Florida to provide services, including serving as a custodian of public records, and then not fulfilling those obligations and not taking any meaningful steps to fulfill them. In other words, by all outward appearances, they've taken no steps to actually do what they agreed to do and to be paid to do. I would say that constitutes fraud. If I go down South Florida Avenue out here offering to wash the windows of all the businesses and I don't own a squeegee and don't own a bucket or don't have access to water or a sponge or soap, and I have no intention of actually doing what they're paying me to do, I think that would constitute fraud. And I think that state contractors, and the Wantman Group being one of them, has done exactly that they have taken money to do a job that they had no intention of doing. I'd be delighted to see exactly what records the Wantman Group has that shows that they've adopted a retention schedule as propounded by the Secretary of State's office. I'd love to see any document retention schedules they have for any records they've destroyed in the fulfillment of their contract. I'd love to see any records that show they've sent anybody to any kind of public records training, that they've ever bought a Sunshine Manual, that they've made any effort whatsoever to serve effectively as a custodian of public records. I doubt that they have. Yet they've taken the money, like gobs and gobs and gobs of other state contractors. So I find it kind of ironic that somebody would describe as fraud engaging in civil litigation that results in improved access to public records by the public for some dollar amount. Now, I think that there's a possibility of fraud in doing that. For example, if somebody were to say, my legal fees are $10,000 when their legal fees really are only $1,000, I think that potentially would be fraud. But saying that I'll settle the case for $5,000 when my expenses are really only $100, so long as I'm not misleading someone to believe that I'm not claiming my costs are $5,000. I'm saying I want $5,000. You want me to give up my right to be vindicated in court? Give me $5,000. I think that's perfectly fine. There's nothing fraudulent about that. That's a nonsensical narrative that he's portraying. I mean, it's not based in fact.
But he's the star, if we remember right.
Like I said, even Ringo Starr produced some crappy songs. To say that is extortion, plain and simple, if that's true, then every attorney who does any kind of tort litigation is engaged in extortion. A few years ago, my father-in-law was in a terrible head-on collision. Very nearly killed him. It was not his fault. He was completely in the right. It was a life-changing experience for him and for our family. It required him to have months and months and months and months of very intensive care by professionals and by family members. The family hired an attorney here locally that I have a very good relationship with, and he filed suit against the insurance company of the other driver, and the threat of protracted civil litigation caused the insurance company to decide that they would rather just go ahead and write a check and be done with it. It was the threat of protracted civil litigation that caused them to make that choice. Is that extortion? Of course not. That's the policy of the state of Florida to encourage that kind of conduct. That's what the Florida Supreme Court has said. If we didn't do that, the courts would be clogged to a point that nobody would ever get any kind of meaningful judicial review. The entire practice of civil litigation is based on the idea that people are going to be forced, persuaded, cajoled, pressured into settling cases. And very often they're settling them for money. That's not extortion. And there's already a remedy in place for frivolous litigation in Florida. It's a 57105. If a party or their attorney files a pleading that they know or should have known had no merit based on the current state of the law, then they're subject to sanctions, including attorney's fees for the other side. We already have a mechanism for dealing with this. So attorneys aren't supposed to, they do sometimes file frivolous lawsuits, but they're not supposed to file frivolous lawsuits, and there's a consequence if they do. But to suggest that suing a government entity or someone acting on their behalf for violating the law and then being willing to settle the case is somehow extortion, that's just nonsense. And I guess my question would be, would the establishment rather, in my case, that I don't settle cases? That we go the distance on every single one of them? Now, if I did that, they would be screaming bloody murder saying that I was just trying to run up attorney's fees, even though I'm not an attorney and I don't get any fees. I mean, you can't have it both ways. If the case has no merit, file a 57105. Let's go to a 57105 hearing. If the case isn't frivolous and there is merit, which it is by definition, it's meritorious if it's not frivolous, then don't be mad at me for being willing to settle this to try to save everybody time and money. If you're going to also whine about me not settling and claim that I'm just trying to run up attorney's fees, well, which one is it? The narrative that you read is just utter nonsense. And none of the defendants that were sued when I was at the Citizens Awareness Foundation, at least any cases that I signed off on, the defendants were in fact subject to the Public Records Act. and it's very clear they were subject to the Public Records Act because they signed contracts that said that they were. They knew they were. This wasn't Schwab-Twitty litigation where there's some nebulous uncertainty about whether they're really subject to the Public Records Act. I don't engage in that kind of litigation. The litigation that I've engaged in, both now and before I went to work for the foundation and when I worked for the foundation, was against entities where there is no question that they are subject to the Public Records Act. And everybody has this, and I say everybody, so many attorneys just show their utter incompetence when they try to argue, well, this doesn't meet the totality of factors test or the Schwab-Twitty test, or it doesn't meet the delegation test. They're forgetting that if you look at the Sunshine Manual, for example, there are three things that make somebody subject to the Public Records Act. One is you're a publicly operated agency. Two, you're acting on behalf of a publicly operated agency and are subject to the totality of factors test or the Schwab-Twitty test or the delegation test. Those are the first two. And the third is a contractual obligation. All of these have contractual obligations, and those contractual obligations are there as a matter of law. Section 287.058 of the Florida statutes, and if you read the preamble to this section of the statutes, the legislature was very clear. The reason they're going to require the Category 2 procurement contracts, that's contracts that are worth $35,000 or more from state agencies, have to have language that explicitly say that if the contractor is subject to the Public Records Act, and if they refuse to comply with the Public Records Act, that the agency is authorized to immediately and unilaterally terminate the contract. The contracts aren't valid unless that language is there. And if you read the preamble as to why the legislature created that requirement that that contract language be there, it's to maintain public confidence in the procurement process. So the taxpayers are able to see what private organizations who are getting a bunch of government money are doing with that money. Are they ripping off the taxpayers, or are we getting what we paid for? So this narrative, which is just utter nonsense, it's just made up, that these organizations, these private organizations like Wantman Group, aren't subject to the Public Records Act. Okay, does that mean that they just get to unilaterally pick which parts of the contract they're going to comply with? And the answer is no. Now, that they do, but that's not what's supposed to happen. I find it interesting. This is why people hate attorneys. I don't hate all attorneys. I have some very dear friends who are attorneys. But the reason people hate attorneys is because they talk out of both sides of their mouth. I bet you that Jerry Richmond, the rock star that he is, has hundreds of times engaged in exactly the same kind of conduct he's criticizing. I bet hundreds and hundreds of times he has negotiated a settlement with somebody with the alternative being protracted and expensive and burdensome litigation. I mean, he does it all the time. Bob Sweetapple does it all the time. The guys on the phone do it all the time. Attorneys do this all the time. The problem is they don't like you doing it to their clients. When you do it to their client, then it's extortion. But if they do it, well, that's why I went to law school. The Supreme Court has said that it's a policy of the state to encourage settlements in civil litigation. So I would say that that's a fictitious, nonsensical narrative that Jerry Richmond gave to the media. It's just not true.